in apex courts all over the world on very, very toxic or very difficult subjects that happen in our life. This is the end of life litigation. I've looked at America, the Supreme Court of America, Supreme Court of all the countries in the world. We have fantastic judicial minds. What is it that I'll be able to bring which is not there? Access to justice was very well done by the first Chief Justice. Second Chief Justice did as much as he could, but access to justice is both qualitative and quantitative. It's not enough to have courthouses. It's not enough to have many judges and many magistrates and many tribunals and everything. What we now need is another transformative agenda: expeditious disposal of cases. Expeditious disposal of cases is the one that will take Kenya to the next level. It is heartening to hear of cases staying in the court processing, being processed in court for 10 years. We should be looking at a possibility of a case, and we can do this, and I've listened to other Chief Justices. I'm a keen listener of the Chief Justice of South Africa, Mogain, and what he's trying in South Africa is a case management system that can process a case from filing to the determination of that case. Why we must have this is because without it, we'll never know statistically how well we are doing. That would be my mission and my agenda.
Okay. Thank you very much, Senior Counsel. One last question from me. In the CV, you have said that you have avoided to be a conspicuous consumption person. But please explain what you meant, because looking at your wealth declaration, Mr. Ngatia, I saw very high-end cars. So isn't that conspicuous consumption, or what did you mean?
No, Prof. Conspicuous consumption has many aspects. I meant social circles. I meant that I am not in social circles. I'm not in lots of the new approaches in life. I do prefer to hold to my own. I prefer the solace of being in a library as contrasted to being in a social circles. And I must say I'm one of those lawyers who are not on the social media, any of the social media platforms. I'll prefer to hold my peace, and therefore I indicated I'm not in those social circles. And I do not mean to say that those who are any less or doing any worse. It's a question of choice.
Thank you very much. I'll now request Commissioner Mulu, acting CJ, to ask you further questions.
Thank you. Let us conclude the discussion, Senior Counsel, that you have begun with the Chair on leadership. And that leadership must of necessity lead to the reforms that we have already begun and which must be continued. And since you appear to admire Chief Justice Mutunga, let me start at that point. On the 19th of October 2011, when Chief Justice Mutunga was addressing the judiciary and the nation at large, he said the following words, and I quote him: "We found an institution so frail in its structures, so thin in resources, low in its confidence, so deficient in integrity, so weak in its public support, that to have expected it to deliver justice was to be wildly optimistic. Now, we want you to please put that into context, Senior Counsel, in terms of the transformation, not what has already been undertaken, but the transformation that Senior Counsel would progress, were God to grant that Senior Counsel becomes the 15th Chief Justice of the Republic of Kenya.
Yes. Chief Justice Mutunga, I think, was being very philosophical with certain words. Being low in public support, I can see that as a direct attribute of the events 2 years or 3 years prior thereto, where the public support to this institution was at its lowest level, culminating to a presidential candidate declining to have his dispute litigated in court. And with that came lots of other events. And one of the issues that I would wish to deal with, and that is why I would wish to gain public support, is that if a case is filed on 1st January, within that year, it should be concluded. Commissioners have also done a little bit of reading, and we have real life problems in this country. I saw for example, in Costa Rica, an empirical study which has been done. If you get your criminal justice system working quickly, there is an immediate reduction in crime. But here, what we do is the exact opposite. We make our justice system work so slowly. Consequently, there can be a reduction in crime. If we wish to get public support, expeditious disposal of cases becomes a very important thing that we must implement. Deficiency and being thin on resources, I see that happening because it's at that time of Chief Justice Mutunga, I think judiciary had not had its pride of place in the Constitution. We also have the history we are dealing with. When I was joining Attorney General's chambers in 1980, judiciary was a department under the Attorney General. And that is why in the Waruhio Commission, he actually makes a direct recommendation. Let judiciary be away from Attorney General's chambers. Therefore, the transformation journey not only is to divest or to have judiciary stand on its own under the Constitution 2010, but we also have its own independent funding structures. And again here, DCJ, I would wish to say all those tools are provided for because there is a judiciary fund. And the Constitution of Kenya only establishes 3 funds: Consolidated Judiciary Fund and the Equalization Fund. Consequently, the framers of this Constitution want us to get away from the frail judiciary which was there in 2011 to a very robust judiciary, which is where we want or would aim to have this judiciary get into. I see Chief Justice Mutunga's words as words of hopelessness and frustration in one word, because across them it is the hopelessness of the situation that he's being confronted with.
Senior Counsel, then you would of necessity have to take us out of that hopelessness. Are we still there? That was 2011. Fast forward to 2021. Would you still describe the institution of the judiciary to be in a state of hopelessness?
Far from it. We have made such tremendous progress.
And therefore, then, Senior Counsel, what would be the role of Senior Counsel, were he to be Chief Justice, to move us from here to a place better than what Senior Counsel would have found by the time Senior Counsel was retiring as Chief Justice?
I see myself being in more or less the same position as Singapore was in 1980. Singapore had a huge backlog of cases. I have done a special reading of Singapore and the backlog of cases. And within 4 years, and everything built, they did this with some assistance from the World Bank, but I do believe, with or without that assistance, they had the mental, they had the determination to do it on their own. It's one of the shining examples of what can be done within a relatively short period of time within a judiciary that really is interested in moving forward. So to answer you directly, DCJ, I'll be the Chief Justice that will end the backlog and simultaneously have the expeditious disposal of cases, not as a theory, but as a practical thing. I would wish to see a criminal case started and within 6 months there is a determination. I would not want to be the Chief Justice of criminal cases staying for so long that witnesses disappear and acquittals are because of the delay in the justice system.
Thank you. I think let us pursue that a little. We have the justice chain players. How is my Lord Chief Justice Ngatia going to achieve a criminal determination within 6 months? Will Chief Justice Ngatia force magistrates or judges to go on with hearings where the other justice players are not playing ball? It is advocates who at times will seek adjournments. I'm aware the court is in control or ought to be in control of the case, but there will be genuine reasons for an adjournment. There will be other maneuvers undertaken by the other justice players, the investigator, the prosecutor, so that the case is not ready and therefore not able to be finalized within this period of 6 months that Senior Counsel Ngatia proposes. What then, what then would Chief Justice Ngatia do to actually achieve a determination of criminal cases within 6 months?
Thank you, DCJ. Like everything else in life, it's not a one-man show. NCAJ becomes the first port of call. The beauty with NCAJ is that all the other players are involved. And it has got to be from NCAJ that a determination has got to be made that we must move this country forward. Judiciary actually comes at the tail end in, for example, the criminal justice system. Coming at the tail end, there is very little you can do. The investigations are done elsewhere, the indictment, the charges are done elsewhere by a constitutional office holder. There's so much prior to alignment in court that becomes almost determinative to how long the process will take. So I will do my very best at NCAJ to say that we must take this country to another level. I would want to get as much cooperation from the other actors, because they are real actors in this system and without their cooperation, there's nothing that can be done. But the unfortunate thing, Commissioners, is this, that the person who gets the blame from the public is not those other actors, it's the judiciary. And when, for example, and I've done this as an empirical study, when adjournments are also sought by the prosecutors, and they are sought over and over again, a month goes, 6 months goes, a year goes, the person who gets the blame is the judiciary. And those who applied for adjournments do not want to say they caused a delay of 1 year. So it's got to be a collectivity. And the key word here is collectivity of action. And that collectivity will be at NCA. But here, at the end of it all, is a question of whether we want to go the Singapore way, which to me is the correct way, or whether we would want to just stay with what we are doing, which to me is the incorrect way. We must have expeditious disposal of cases.
Thank you. If Senior Counsel were to be Chief Justice, you would have, at the very least, 3 very core functions. There are more, but 3 core. But considering the whole 5 or maybe 6, which would Senior Counsel consider to be the most important role, if that is a possibility, of the holder of the office of Chief Justice, and why would that be considered to be the most important role of the office of the Chief Justice?
As I look at the Constitution, my obvious answer would be the first and fundamental role of a Chief Justice is the head of the judiciary. Being the head of the judiciary has its own far-reaching consequences. You therefore become, so to speak, the titular head, not just the titular head, but the real head, the policy head of the entire judiciary. It's by virtue of being that head of the judiciary that you also have the second hat of presiding judge or the president of the Supreme Court. That role of president of the Supreme Court is a role that I have trained myself for. It's a role that can be played or can be assumed by a practitioner of my standing, and the other roles would be the other commissions, this commission being one of them, NCAJ being another one of them, Council of Law Reporting being yet another one of them, and commissioners, I do have that which it takes to be able to have enough time for all those roles.
Which leads me, Senior Counsel, to the next question. And it is the question of balance between the many roles that the Honorable the Chief Justice is required to execute. So how would Chief Justice Ngatia balance between those roles, and what would guide Chief Justice Ngatia in the balancing act between the roles? You have identified that of the head of the judiciary as, to you, the most important one, but that must not make the others suffer. And therefore, what would be the balancing act? Part 1. Part 2, the Chief Justice, and you've mentioned that, being the President of the Supreme Court, must ensure, in my view, that that court works. Must ensure that as the final court, what comes out of that court is indeed final in nature, so that it really doesn't require explanation and so on and so forth. So balance between the execution of duty of the various roles of the Chief Justice to be able to make yourself an effective Chief Justice?
Thank you, DCJ. As head of judiciary, as I indicated, that's a leadership role. And the beauty with it is that in this judiciary, we have very well established structures, statutory structures, which are very well established. And the Chief Registrar of the Judiciary is the accounting officer. It's not my role to try and micromanage that statutory duty. But I do have an interest to ensure that it's well done. So my first port of call would be the leadership advisory committee, because I would want to carry the entire judiciary or to be with the entire judiciary. I will regard that as my cabinet. Being my cabinet, I'll be able to know what is going on in the Court of Appeal, in the High Court, and courts of similar jurisdiction. In all probability, we should also have a magistrate with us. The CRJ is with us. Heads of directorates are with us. I would want to have very structured meetings with all of them, because that is the cabinet. And with that cabinet, because I'm still ultimately the one reliable, I should be able to know what is going on at every level of this judiciary, including the Cathy's courts and including how many tribunals have transited and what we are doing about it, and including the improvements we can make, like small claims courts and how we get them going. So it's not difficult for me, because I have with me a dedicated team that I do hope I'll be able to work with quite effectively.
Thank you, Senior Counsel.
But if I could explain about the Supreme Court, because you had also asked me about the Supreme Court.
Yes, please.
The Supreme Court, being a collegiate court, I'll be one amongst equals. And what I'll do from day one is to personally call all the Supreme Court judges, and we shall have a meeting as equals. Collegiality, commissioners, does not mean, and I must say this, it does not mean that I impose my views on them. It does not mean unanimity in decisions. That's not what collegiality means. And we, as a Chief Justice, I'll try to have very robust engagements by the judges. I will not stifle them by telling them, look, let's decide this way. Sometimes, in most times, by having individual opinions is the growth of law. But if you stifle it by having unanimity, you are not going very far. But of course, in such certain very divisive topics, like say racial segregation, you'd want to have the entire court with you. But with the ordinary cases that go to the Supreme Court, I would want the individual judges to actually show their best. If I could digress a little, we remember Judge of Appeal Nyarangi, because of his individual opinion in Motorves Aurelian. I may cite this to my Lord every other day about Judge Nyarangi said this, and we all remember him for that. In other words, individual opinions do immortalize judges, particularly if they are well done. I'll be able to balance that work because of my deep desire in development of law. Law is my passion. Instead of other pastimes, I would have time, even in the evening, to read and to generate my opinions. And even in that court, the Supreme Court, I'll try to have the same thing, expeditious disposal of cases.
Thank you very much, Senior Counsel. Let's go to a different area now. You must have come across someone called Montesquieu. You will tell us who that guy is. Tell us what he said, what is he known for, and how does that relate with interdependence?
Very good. That cause for me to quickly remember my reading in philosophy. Up to around 17th century, I may be mistaken, maybe a little earlier, man was living in what can be described as state of nature. A state of nature meaning there was no community or there was no law and order. That state of nature meant you are on your own. Consequently, life was very short, very brutish, very violent. Because of living in that state of nature, although lawyers want to take advantage of this, it is actually philosophers who actually saw a need of moving from the state of nature and to live within a community. And the first, if you could allow me, DCJ, before we go to Montesquieu, the first philosopher who saw the need to move from the state of nature to a community is John Locke. John Locke, or either John Locke or Hobbes, it's John Locke, who actually said that much as we want to go to a community, there are certain rights we cannot surrender. The first right we cannot surrender is life, liberty, and property. But we can surrender other rights of protecting ourselves. We surrender them to this community or this body politic that we shall create. So those three rights which could not be surrendered are today the rights we talk about, which cannot be alienated. But soon after John Locke came Montesquieu. Montesquieu said, even as you move from the state of nature, there is something you are missing. The first thing you are missing is absence of a body that can make laws. Because yes, we are moving now to a society, a community. We have an absence of a body to make laws. Next thing you are missing is an impartial judge. The third thing you are missing is somebody to enforce the laws. So Montesquieu, a French philosopher, is the one who is credited the world over by having the separation of powers. Separation of powers is not a lawyer-driven exercise or initiative. It came from these philosophers of the 17th century. That separation of powers was quickly taken over, as well as the three rights which cannot be surrendered, and the Thomas Jefferson, as you may recall, in his Declaration of Independence, he ran away with it, and in America, the Declaration of Independence, which was done, I think, in 1770-something, had the three rights: right to life, liberty, but then he twisted, Thomas Jefferson twisted the property, and he said, pursuit of our own happiness. So the Declaration of Independence of America is a direct attribute of those philosophers. I hope I have answered you fully.
Save for we would like you to say something about what Montesquieu said, and which I think you have sufficiently explained, related to interdependence.
Interdependence, the beauty with interdependence, therefore, even at Montesquieu level, you have the three powers, for lack of a better word. one creating the laws, another one the impartial judge, and another, the third one enforcing. And this become the legislature, judiciary, and the executive. Their interdependence is that you, as the executive, you require the laws to be enacted by legislature. And as a judiciary, you become the impartial arbiter of any dispute that will arise either horizontally or even vertically. And in that, I see, as a matter of fact, that is the same thing that is today known as the separation of powers within our Constitution. The interdependence meaning that you are not isolated. Could I say this? Judiciary is not created for itself. Judiciary is created as a service industry to the people of Kenya. So if it's understood we are service industry for the people of Kenya, we are not created for ourselves, then we become interdependent because the people we are serving are the people of the Republic of Kenya. Both executive, both legislature, and more important, the 47 million or 40-something million of our citizens. That is our core business.
Thank you, Senior Counsel. I have two final questions. And the first one will be as follows. Would you say that the jurisprudence emerging from the Supreme Court confirms the transformative nature of the Constitution, or it belies it? And while still at the Supreme Court, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the President, arising out of Article 140 of the 2010 Constitution. Please, with the reference to Section 83 of the Elections Act, the various amendments thereto since 2016, and any other relevant jurisprudence that comes to your mind, Senior Counsel, please discuss the role of the Supreme Court in the nullification or confirmation of a presidential election. And please tell us whether that jurisdiction should vest in the Supreme Court, and what the challenges of hearing that important case are to the judiciary as a whole.
DCJ, you put me in a small fix, but I'll navigate. I'll definitely navigate these very difficult areas. The first one is easy. Supreme Court has come up with some very transformative judgments. Very, very transformative. Let me say this. The Murwateto case, although misunderstood and misapplied by courts in Kenya, has won the pride of place all over the world. I do not have, but I can provide to the Chief Registrar. I was just going through my searches around Murwateto. It is quoted with approval in Barbados. A whole paragraph of Murwateto is quoted with approval. Not just Murwateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Murwateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, in Malawi, Zambia, Belize, a few other colonies. But at the time of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to Section 204. For the simple reason that Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report would be there was no such report. I lost track with the Morowateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do. But it's not too late. In the event that you honor me with this position, I'll immediately get to Morowateto, see how the judges who could hear it or to come to terms with how we now do not allow it to be a way of people running away from what are otherwise valid sentences.
Morowateto Senior Counsel is one case. Another one that is transformative?
Another case which would have been transformative but didn't become as transformative as I thought was the arbitration appeals. Because we lost the opportunity of Kenya attracting arbitrations from all over the world like other countries have. That case was going towards making arbitration insular from judicial intervention. The Supreme Court almost reached there but backed out by saying that go back to Supreme Court and let Supreme Court see whether it was. So those are the two that would immediately come to mind. As regards presidential election petitions, could I start off with the challenges? The first challenge every Kenyan would say is the 14 days. It's not a challenge. We have done it 3 times. We have done it because lawyers in this country do believe that you can do tasks within a relatively short period of time. I say this in contradistinction to what happened in Zambia. In Zambia in 2016, they have the same law. The lawyers took 10 days, exchange of papers, another 2 days, case discussions and case conference, and they remembered they have not had their case on the 14th day. So the presidential petition was not heard. It was not heard because they started saying that can there be extension of time? Needless to say, the lawyer for the successful party said it's cast in stone, it's cast in the Constitution. So I do not see that as a major problem. Section 83 DCJ in 2013, it was applied fully. It's on the basis of Section 83 that the election was upheld substantially. come 2017, there were difficulties. The court, the majority decision did not apply, as I remember, Section 83, dissenting judgment, I believe, of Supreme Court Judge Joki dealt with it. But then there was an amendment by National Assembly. Many things were done. The amendments have been struck off, I remember, by one of the petitions by Katiba Institute. So we are in fairly murky waters about the application of Section 83.
We should start hearing that case, Senior Counsel.
Sorry?
Which court should?
A presidential petition, I would, without reservation, say, should be the sole preserve of the Supreme Court.
Reasons?
We have a lot of similar jurisdiction. Malawi, as you know, has the similar jurisdiction. They nullified the presidential petition, I think, last year. If we do presidential petition in any other court, then there will be issues about appellate processes, I do believe. So has won its pride of place by having dealt with 3 presidential petitions, and in all 3, the actors may have had reservations, but by and large, it's now an established jurisprudence of the